Welcome to Bankruptcy Bytes, a video series presented by the United States Bankruptcy Court for the Eastern District of Missouri. I'm Matt Rodman, attorney advisor to the Clerk of Court, and today we're going to talk a little bit about the Section 341 Meeting of Creditors. Before we get started, just remember, the Clerk's office and its staff are strictly forbidden from providing legal advice, as we have a statutory obligation to always remain neutral. The Clerk's office and its staff can tell you the rules and procedures that this court abides by, but we can't tell you what to do. The Section 341 Meeting of Creditors is mandated by 11 U.S.C. Section 341, found in the Bankruptcy Code. Some purposes of this meeting are to allow the trustee assigned to the case and all creditors to determine what assets the debtor possesses, to determine whether the debtor has any claims or causes of action against others that could provide funds to repay creditors, and to confirm that the debtor has provided accurate and truthful information on their petition, statements, and schedules. This meeting usually takes place 20 to 40 days after the date you file your bankruptcy case. Shortly after you file your case, the clerk's office will send you a Section 341 meeting notice. This notice will include the date and time of your meeting and the name and contact information for the trustee assigned to your case. The debtor must attend their Section 341 meeting of creditors. In cases where spouses file jointly, both debtors must attend the Section 341 meeting of creditors. If the debtor is unable to attend the meeting at the date and time specified in the notice they receive from the court, the debtor must contact the case trustee assigned to their case as soon as possible to reschedule the meeting at a date and time they can attend. Debtors represented by an attorney may also contact their attorney and have their attorney speak with the case trustee to reschedule the meeting. Please note, the Section 341 meeting of creditors is a public proceeding. In addition to the debtors, their attorney if applicable, and the case trustee, all creditors and members of the public are eligible to attend this meeting. To prepare yourself for your Section 341 meeting of creditors, you will want to familiarize yourself with your finances and review the information you used to complete your petition, schedules, and statements. Additionally, you will want to gather the materials required to be turned over to the trustee in anticipation of this meeting. Examples of these materials are pay stubs for the last 6 months and recently filed tax returns. Information regarding what must be turned over to the trustee prior to your Section 341 meeting of creditors and how to submit that information can be found on the court's website at www.moeb.uscourts.gov. Please note, each trustee may have specific methods for submitting this information. Now let's discuss what you can expect at your Section 341 meeting of creditors. We have divided your Section 341 meeting of creditors into 5 parts: an opening, a confirmation of the debtors in attendance, an oath, a review of the debtor's personal information, and a review of the debtor's financial information. The opening often includes an overview of the meeting itself, an explanation of the differences between different types of assets, and a reminder of what bankruptcy fraud is and how an investigation of suspected fraud could affect your bankruptcy case. Next, the debtors will confirm their attendance. The names of all debtors listed on the docket will be called to confirm their attendance. Each debtor will take an oath in which they will promise under penalty of perjury to answer each question completely and accurately. After taking the oath, the debtors will then be questioned about their personal information. Debtors will confirm that their name, address, social security number, and photo ID match those filed with the bankruptcy court. Debtors will also verify that any signatures and/or handwriting which appear on documents they filed with the bankruptcy court are indeed their own. And finally, debtors will be questioned about their financial information. The debtor will provide information about topics including, but not limited to, their property, both currently and recently owned, bank accounts, any domestic support obligations such as child support or alimony, their income and expense, and any outstanding financial obligations. Everyone's situation is a little bit different, and for the best individual assistance, the clerk's office recommends all debtors and prospective debtors speak with an attorney to get expert advice on the right path for them. If you would like to speak with an attorney regarding your recent or upcoming bankruptcy filing, the Bar Association of Metropolitan St. Louis hosts the St. Louis Bankruptcy Pro Se Assistance Program. This program offers cost-free 30-minute sessions with an attorney where the prospective or current debtor can get the answers to some of their questions. To schedule an appointment, you may call 1-844-758-4059 or schedule online at www.bamsl.org/bankruptcy. Thank you for tuning in to learn about what to expect at your Section 341 Meeting of Creditors. This video has been part of the Bankruptcy Bytes series presented by the United States Bankruptcy Court for the Eastern District of Missouri. I'm Matt Rodman, Attorney Advisor to the Clerk of Court. On behalf of the clerk and the entire clerk's office staff, we hope you found this information helpful and we wish you all the best moving forward.